children. Would ask that everyone please silence your phones, and Madam Secretary, please call the roll.
Senator Chambers Armstrong. Here. Senator Elkins.
Here.
Senator Girdler. Here. Senator Mays Bledsoe. Here. Senator Meredith. Present. Senator Tishner. Senator Webb. Senator Westerfield.
Here.
Senator Wise.
Here.
Vice Chair Rocky Adams. Chairman Carroll.
Here. We have a quorum, and we are duly authorized to conduct business. We have two bills on the agenda today, and then a third that will be heard for discussion only. And then we also have some administrative regs to hear. First on the agenda is House Bill 333, and this is an act relating to prosecution proceedings. Representative David Meade. Representative, welcome. Please introduce yourself, and if your guest would also please introduce herself for the record, and you all have the floor.
Thank you, Mr. Chairman and members of the committee. I am David Meade, Speaker Pro Tem of the House.
Good morning. I'm Jenny Oldham. I'm the Hardin County Attorney and President of the Kentucky County Attorneys Association.
This is a very simple bill. What happened is Senator Rocky Adams passed a very good piece of child welfare legislation last year, and in the legislation, it was her intent that the attorneys at the Cabinet for Health and Family Services at DCBS, if they so chose to intervene in a case, a DNA case, that they could do that with permission from the county attorneys. However, that interpretation of the way it was written was that they could intervene at any time they wanted to. So this bill simply corrects that. Instead of saying upon written notice to the county attorney, it just says upon written consent of the county attorney, and that is the entire bill.
We have a motion and a second. Any questions? Madam Secretary, please call the roll.
Senator Rocky Adams. Senator Chambers Armstrong. Aye. Senator Elkins.
Aye.
Senator Girdler. Aye. Senator Mays Bledsoe. Aye. Senator Meredith. Aye. Senator Tishner. Aye. Senator Webb. Senator Westerfield. Aye. Senator Wise. Aye. Chairman Carroll.
Aye. Vote 9-0. Bill passes with favorable expression. We have a motion and a second for consent. All those in favor, please signify by saying aye. Aye. Opposed, no. Consent motion carries. Congratulations, Mr. Speaker, and we will move this bill to the consent agenda.
Thank you, Mr. Chairman and members of the committee.
Thank you. Next on the agenda, we have House Bill 561, an act relating to child care, sponsored by Representative Samara Heverin. Welcome, Representative. Mr. All, welcome. If you all would please introduce yourselves for the record, and you have the floor.
Thank you. My name is Samara Heverin. I'm the 18th District State Representative. I represent all of Grayson County and a portion of Hardin County.
And Charles All, I'm the Executive Director of the Kentucky Chamber Center for Policy and Research.
Mr. Chairman, I do believe that there is a committee substitute. If we could move forward with that first.
We can. Have a motion on the sub?
So moved.
We have a motion and a second. All those in favor, please signify by saying aye.
Aye.
Opposed? Sub is adopted. Please continue.
Thank you, Mr. Chairman. All the committee substitute does is make a technical change that the bill drafter found after it passed the House. So we thought we'd go ahead and get that cleaned up in the committee. Mr. Chairman, we have both been working diligently on child care issues for the last 2 years. And I think that our life experiences bring us to different ways to approach the issue. And for that, I'm thankful because the legislature brings us different life experiences and opportunities. And so during our time and conversations that we've had, a lot of people have talked about how one of the biggest impediments to opening child care centers is local zoning and land use policies. And so I don't always brag on Louisville being a rural legislator, but I do appreciate the economic engine that they are. But a few years ago, they did a really great thing, and I think that was led by Senator Cassie Chambers Armstrong. And so I really, being able to open up more child care centers is a big thing right now, and we need that. So what House Bill 561 does is it creates certified child care communities, and it brings access to affordable, high-quality child care, and it's a critical workforce and economic issue. And so increasing access to child care benefits everybody. It benefits kids, working families, our workforce, and our economy. And so House Bill 561 is an innovative approach to encouraging local governments to study land use rules with the goal of identifying barriers to child care and implementing reforms. Now, let me say, I see Senator Girdler in here. This is not a mandate, Senator Girdler. This is just an encouragement to local governments. And so the bill imposes no mandates to local governments and fully upholds local control. It creates opportunities for collaboration and economic development by making available a new voluntary certified child care community designation. This is very simple.
We have a motion and a second. Are there any questions? I appreciate you bringing this bill, and we have talked often that much of this issue can be solved at the local level, and it's imperative that our cities and counties get involved in this and find solutions that are suitable for their area. So I thank you very much for this, and Madam Secretary, please call the roll.
Senator Rocky Adams. Senator Chambers Armstrong.
May I explain my yes vote, Mr. Chair?
Proceed.
I just wanted to say thank you for your work on this. It's a really important bill to make sure that government isn't being a barrier to a lot of these businesses opening. I think it's going to help a lot of people get childcare near where they work and where they live. So thank you. I'm proud to vote yes.
Senator Elkins.
Aye.
Senator Girdler. Senator Mays Bledsoe. Senator Meredith.
I'd like to explain my vote, please.
Proceed.
I vote aye. And I also want to thank Representative Heverin and you, Chairman Carroll, for your work on child care issues this session. This is a big problem to tackle, and I'm not sure we'll find all the answers this session. It may take us in several sessions to get where we need to be, but every measure we can take to move this forward certainly helps the situation. So thank you for bringing this bill. Again, I vote aye.
Senator Tishner. Senator Webb. Senator Westerfield. Senator Wise. Chairman Carroll.
Aye. Vote of 9-0. Bill passes with favorable expression. I have a motion for consent. Do I have a second? All those in favor, please signify by saying aye. Aye. Opposed? Motion carries. Bill will be carried on the consent agenda. Congratulations, Representative. And again, thank you.
Thank you,
Charles,
Mr.
thank
Chairman.
you for being here. Appreciate all your efforts. Okay, I think we're going to go out of turn a little bit and go ahead and get these admin regs out of the way. Are there any questions? Those that are here from the cabinet, are any substantial changes in any of these regs related to, more specifically with the family child care homes and the Child Care Assistance Partnership?
Good morning. My name is Laura Began, DCBS Regulation Coordinator. There are not substantial changes in these administrative regulations. The Certified Child Care Home Reg contains standards that were required to be updated as a result of a federal audit. We've had a few regulations going through the process for that. So they make updates relating to safety, health and safety in those homes, specifically around swimming pools and keeping children away from traffic. For the Employee Child Care Assistance Partnership, we, again, really just clean up as a result of House Bill 165 from last year and changes that we needed to make to the forms as we gear up to make that application process electronic this year. So everything is on target for that.
Okay, do we have any questions? Senator Tishner.
Thank you. I was reading through these, and forgive me, I don't have it in front of me, so I believe it was 922-2100 that struck out family care meetings and replaced it with consultation. Can you explain why we're taking out a family meeting? And
Sure. Yes, ma'am. That is in the high-risk supplement administrative regulations, so that is relating to children in foster care. We really just changed the wording around it to allow for flexibility of who all is in that team meeting, as that differs from case to case around foster children. Yes, ma'am.
Any other questions? Seeing none, we find these administrative regs to be reviewed. Thank you very much. Okay, the last item that we have on the agenda is for discussion only. We will not be taking any votes today as far as adopting a sub, and this will be Senate Bill 242, which was a shell bill that I filed. If I could please ask the folks from Cabinet Health and Family Services, Justice Cabinet, the Hospital Association, if Nancy is here. This bill is one that we have been working on intensely throughout this session, and we're a little bit late getting it out, but it's because we wanted to get it as complete as we possibly could. And this bill is a continuance of the efforts that we started last year with the DJJ working group. And this bill focuses primarily on acute mentally ill youth. And then there are some DJJ issues that we needed to clean up and some adjustments that we needed to make to legislation that we passed last year in Senate Bill 162 and House Bill 3. We've been working very closely with CHFS, with the Justice Cabinet, and both the secretaries here today, with the Administrative Office of Courts, and with the Hospital Association. So you can imagine, with 4 different groups with different priorities, the difficulty of putting all this together. But I think we have a really good product. Roberta back there has done an outstanding job of putting everything together in a way that flows, and I think this is something that's really going to make a difference in dealing with high acuity youth. And I'm going to go over some provisions of the bill first, and then allow the secretaries to fill in whatever I might miss on this. And this is going to get a little bit complicated and in the weeds, but I just want to hit each part of this real quickly. And if you all have any questions, please let me know. I want to start with just giving a definition of a high acuity youth. And it's a youth that's been determined by a clinical professional following a behavioral assessment to need an environment and specialized treatment capable of addressing manifest aggression, violence towards persons, or property destruction. So these are the highest level kids that we deal with. And we've talked many times about the female that was in the juvenile detention center and the condition she was living in. This is that level of youth that we're talking about. There will be 2 different types of hospitals. So if you hear me use the term hospital, it will be referring to an inpatient psychiatric hospital or a pediatric teaching hospital. And these are the 2 types of hospitals that would treat these individual kids. And when I refer to a DJJ detention facility, understand for now that means just a regular detention facility. Part of this bill and part of a budget proposal that we have submitted is to build a DJJ high acuity mental health detention center. This would be a 16-bed facility. It would be staffed security-wise by DJJ. It would belong to DJJ, but this would be a partnership with the Cabinet of Health and Family Services, who would provide the mental health treatment. So juveniles, youth, like this young lady we talked about, this is the type of facility that those kids would be in, where the focus is on treatment and not detention. This is kind of breaking new ground from what I understand, and really difficult to find any model in the country that's currently doing this. So we will have to make adjustments as we go. It's going to take 18 plus months to build this facility. We have time to do that in upcoming sessions, but this will get the ground laid for that. And so understand, when we talk about the DJJ detention, ultimately that's the type of facility, or the facility, that we're talking about, and we hope that this will be located at Central State Hospital on those grounds. Okay, in the bill, in Section 1, it establishes the process by which a juvenile taken into custody by DJJ or a youth committed to CHFS receives a behavioral assessment to determine whether or not the youth qualifies as a high acuity youth. If the child does, it requires the clinical professional for the inpatient psychiatric hospital or pediatric teaching hospital to contact the designated representatives from DCBS and DJJ to discuss an immediate treatment plan. It requires the clinical professional to prepare an affidavit for submission to both cabinets and summarizing the clinical evidence to support the determination that the child qualifies as a high acuity youth. It recommends an appropriate location for inpatient treatment based on the child's needs and capabilities of the hospital, or whether treatment on an outpatient basis may be best provided at a DJJ detention facility for a child in DJJ custody or at a location specified by DCBS if the child is in the custody of CHFS. If the determination is made that it's in the best interest of the child that the child should receive services in a detention facility, eventually the hospital that we refer to, the inpatient psychiatric hospital or pediatric teaching hospital shall provide contact information on one or more clinical professionals who can provide the type of care the youth needs. And I apologize, allergies are kicking up this morning. If DCBS or DJJ disagrees with the treatment recommendation, they have the ability to file an affidavit of dissent with the court, including a request for an alternate assessment of the child. The court, once it reviews the affidavits, shall enter an order regarding the care for the youth. And it specifies that the court shall not order a high acuity youth for inpatient services with a hospital without the agreement of the hospital, DCBS, and DJJ, unless the court determines by clear and convincing evidence the hospital has the resources and capabilities to treat the high acuity youth. It does not require a psychiatric hospital or teaching hospital to admit a high acuity youth if doing so would be in violation of federal law. It establishes the DMS reimbursement rate for inpatient hospital care at 200% of the then current Medicaid rate. It establishes the outpatient rate for services provided by these hospitals at DJJ detention facilities at 150% of the current inpatient Medicaid rate. Establishes reporting requirements and dispute remediation through the courts. Establishes the process to remove a high acuity youth from a hospital if the youth commits an act of violence or incites violence. Through the course of meetings with the hospital association, with the cabinets, we discovered that one of the reasons that these hospitals are reluctant to take high acuity juveniles is the belief and the practice that once those kids are there, they're there. And they could beat staff daily, nothing is being done. Law enforcement, the courts would not take those kids back, remove them from that facility. In this bill, we clarify a process to make sure that those children can be moved to a detention facility through, again, the process of collaboration with the cabinets and a judge making a final decision. And it also establishes that should a child, law enforcement just show up with the child without having gone through the assessment process, that the hospital can, following the assessment, return the child to the custody of the courts for placement in a detention center if they are unable to provide treatment for that child. This requires that hospitals that accept high acuity youth have protocols in place for 24-hour access, provides for a process to move a high acuity youth to a lower continuum of care if the treating physician determines that the current level of care is no longer needed. Sets processes to be followed if a high acuity youth is delivered to the hospital without a referral. Allow a clinical professional to present the affidavit to the law enforcement officer or CDW to return the youth to the custody of the delivering agency. So that's the crux of the bill as far as that process goes with the high acuity youth. This is a standardized process whereby there is an assessment done. There are communications between DJJ, DCBS. If there are disagreements in that assessment, then DCBS, DJJ can petition the courts to do an independent assessment. And all this information goes to the judge, and the judge makes the decision on the placement. And again, if the placement is to one of these hospitals and that youth assaults staff members there, if they are not already justice involved, they can become justice involved at that point and be removed from that facility. So they're no longer are these hospitals having to maintain these children when they do not have the capacity to do that, to handle the violent acts that are occurring. And again, this is the hospital the facility, the DJJ facility that we plan to build is critical to the success of this process. And we really feel like it's going to provide better care. It's going to allow for our hospitals to be more comfortable to take more kids in. And as a result of these meetings, and Secretary Friedlander may want to talk on this more in a minute, we're starting to see the dam break with the continuum of care of these different services. We're seeing more facilities that are agreeing to expand as far as beds, to expand the services they provide. So things are moving in the right direction in this area. This was the priority based on what we learned in the working group last session. And we really feel like this process that allows kids to move back and forth based on need, judges making decisions, not the cabinet, not the hospitals. And we really feel like this is a good process that will be in the best interest of the kids that we serve, kids who are either justice involved or coming in through the Cabinet of Health and Family Services. Section 2 of the bill has more to do with DJJ. This bill will allow DJJ to determine the appropriate levels of security for basically each of their facilities. Lists the types of facilities to be operated by DJJ to include an inpatient acute mental health facility that I spoke of. And this will be a residential treatment facility. It requires that by February 1st, 2026, DJJ shall be operating at least 2 female detention facilities for female offenders and shall segregate the violent from the nonviolent offenders. When we decided to direct DJJ to go back to the regional model, they did a study, and the cost to separate male and female, violent, nonviolent, was too great. And so the proposal was made to be able to separate the males, violent, nonviolent, in our regional facilities, and it would be more fiscally responsible to build, to begin with, 2 female centers. The first 2 to be located, one in central Kentucky, Fayette County area, one in western Kentucky. And these locations were established by a study of the population of females in detention centers. They were able to clearly show that these 2 locations would serve the vast majority of female offenders in the Commonwealth. Should there be a need for a 3rd or 4th facility, one will go in eastern Kentucky, one would go in northern Kentucky, and the first one built would be based on another study of the population of female offenders on where the most of those females are coming from to decide whether or not that facility is built in eastern Kentucky or northern Kentucky. The bill also established the conditions that would lead to the construction of the additional facilities in the region that these facilities would be located in, restates the requirement to go back to the regional detention center model by February 1st, 2026, and it allows DJJ to reassign where a youth is housed based on safety or security concerns. Deals with the per diem rate charged to a local government, that shall be established by administrative regulation. It allows DJJ to contract with one or more inpatient hospital or other behavioral health providers to provide outpatient services to children needing services while in detention facilities. Section 3 has definitions. Section 4, it resets the date of the automatic 48-hour detention of a violent offender from House Bill 3 from last year to February 1st, 2026. And we're doing this in order to give time for the completion of the retrofits for the regional detention centers, especially the one in downtown Louisville. Section 5 has to do with confidentiality of juvenile records. It just clarifies that any public official who accesses these records shall not disclose to a third party without a court order. This also allows DJJ to publicly release information regarding a juvenile who has absconded or escaped from a DJJ facility. The information includes the name and county of residence, a physical description, name of the facility from which they absconded or escaped, a photograph, and a statement that the public should use caution and should notify law enforcement immediately if the juvenile is seen. It establishes that when an adult or juvenile who is the subject of information designated confidential, public, confidential publicly reveals or causes to be revealed any significant part of the confidential matter or information by filing a civil suit. The confidentiality shall be presumed voluntarily waived, and DJJ or the Justice Cabinet may, in the defense of the litigation, disclose confidential information and records about the person making or causing the public disclosure, including information that has not been previously disclosed but is related to the information made public. Section 6 removes some confusing language in KRS 645-280 that we believe was being interpreted to mean that once a high acuity youth is in a hospital, that they cannot be removed from that hospital for any violent acts committed. Section 7 simply defines a youth alternative center and a facility as a facility operated by a local government and approved by DJJ for the non-secure detention of a juvenile. Sections 8 through 16, conforming language. Section 17 clarifies the conditions under which a status offender shall be charged with escape. Section 18, conforming language. 19 is definitions. 20, conforming language. And then 21 directs the Justice Public Safety Cabinet to construct a high acuity mental health facility for residential treatment for children in DJJ custody. The facility shall provide beds for 16 children and shall be designed in a manner that shall provide for additions to the facility to increase capacity as needed. Justice and Cabinet for Health and Family Services shall collaborate to ensure compliance with all mental health facility requirements, both federal and state. Section 22 directs CHFS to provide or enter into contracts or MOUs with a public teaching university in this state to provide clinical services to the health facility to be operated by the Justice Cabinet through DJJ. And then Section 23 again directs the Justice Cabinet to continue implementing the plan to transition back to the regional model for juvenile detention facilities while continuing to safely segregate males and females in violent and nonviolent offenders. And then finally, Section 24 requires the Finance Cabinet to report to the LRC no later than August 1st, 2024, the status of the transfer of the property deed of the Jefferson County Youth Detention Center. This report shall be referred to the Interim Joint Committee on Families and Children for review, and if the transfer has not been completed at that time, the report shall include the expected date of the transfer. One of the holdups that we're having on this entire process is being able to get that deed transferred so the retrofitting can take place in the downtown Louisville Center. My understanding is that there are old bonds that have been paid off that are pending that they need to be released from, so we can allow all of that to happen. Committee members, I know this is a lot, and I apologize, and that's why we're doing this just for a discussion today, to give you all a week to absorb this and talk through it. If you have recommendations where we can make changes to it. At this point, I'm going to yield to the secretaries. In general, if you would, please introduce yourselves for the record. And anything that you want to clarify or expand on or any comments, please feel free.
All right. Good morning. Good morning. My name is Keith Jackson, Secretary of Justice and Public Safety. And I just want to begin with the fact that working with Secretary Friedlander and Senator Carroll has been eye-opening.
Is that good or bad?
That's very good for the new guy. But, being in the process, when we first came 2.5 years ago, myself and then Secretary Harvey, we had really no idea of what was going on in DJJ because there were no kids. And so as we began to learn about the issues and problems, we began to work hard towards getting where we are today. Since I've been in this seat in January, I've met with Secretary Friedlander outside of our normal working days, even on a Sunday. to begin a plan that we could present to Senator Carroll that he thought was feasible. So as we move forward, and as we have moved forward, I'm very grateful for the opportunity that Senator Carroll gave us to work together and to offer the changes that we need going forward with this plan. So when we look at the direction that we've gone in, we've been very thorough in our cabinet, and I want to commend Rebecca and Leah and Morgan and Natalie for educating me to where we are today, which gives us a bill that I think is going to not only move DJJ in the right direction, but also us nationally being recognized, as Senator Carroll talked about, with that mental health facility that we want to build that is secure. And the security aspect of it, I think, gives comfort for dealing with the youth that we used as an example. She did not deserve to be in detention. She deserved to have treatment and care, mental health care. And so that's the direction that we're going in reference to what I see as an innovative, progressive move towards the safety of our youth as we go forward. The primary focus of our mission going forward is the safety of the youth, and the adjustments that have been made that Senator Carroll has pointed out laid a foundation for that as we move forward. And we look forward to working with you as we. This is a work in progress, so I want to say that as you work with us, we want to definitely be open to your suggestions and move forward in a direction that's beneficial to the Commonwealth of Kentucky. So with that, I'll turn it over to you, sir.
Okay. Thank you, Eric Friedlander, Secretary of the Cabinet for Health and Family Services. First, I want to say this is a complex issue. You would think we're supposed to take care of kids; it shouldn't be that complex. But it ends up being really complex between the courts, between DJJ, between the cabinet, between the hospital association, providers, so many different perspectives on how to do this well and how to do this right. Senator Carroll, in particular, I want to thank you. You've dug in on this, right? And you've held our feet to the fire, and you've pushed us forward. And I want to let you know how much I appreciate that. We come back and, you hear from Justice, you hear from us, you hear from courts, you hear from the hospital association. We're all saying something a little different. And you let us know that was unacceptable and that we needed to focus on the kids and making sure that we were taking care of them. And we were, but I think your leadership really, really helped us there. So I just want to say thank you for that. None of that was easy. Secretary Jackson, I just want to say thank you. We really, the relationship between CHFS and DJJ is good. The meetings outside of work, just to sit down and talk and come to what should be. I don't know. I think I've told y'all my two skills are my firm grasp of the obvious and my ability to recognize somebody else's good idea. Here, it took us a while to sit down and talk through and well, of course, right? DJJ needs to take care of the security. We need to help with taking care of the behavioral health. Of course, right? So that really was, I think, for us a breakthrough, for our staffs a breakthrough, for when we were talking with you a breakthrough. Then we had to get through, the facilities and the providers and their fears, right? Because they had real experiences of kids who were such a security risk, right? Or had acting out in ways that were violent. That the need for security before we could get, or as we were getting to behavioral health services was really clear and really necessary. And I think as they described in the meetings with you, I think it was a revelation to you about, this is why there is some reluctance, right? And with some justification. So working through that, I think this is progress. It is good progress. I think we will be in a better place, and are in a better place than we have been. Still lots of work to do. And I want to say this as well. A kid that comes in to DJJ, a kid that comes in to CHF custody, right? We need to get in front of that. That kid, we fail that kid. We fail that kid. We fail that kid when they came into our custody, right? So upstream, right? So those things that we do to prevent that, to work on that, to help families, right? So that they hopefully can be able to stay together as much as possible. Those are things we need to focus on each step of the way, so we don't get to the 16-bed facility, the high acuity, high security facility. We need to hope we never fill that place up. So there's a lot of work to do. There will be a lot of work to do, but we've got to take care of those kids, right? And we have to stop producing them. So again, I just want to say thank you, staff. You did a great job. I don't know how you wrote it. So I really think this is what I think is another one of those examples when the executive branch working with the legislative branch, making sure that we're putting kids at the center there. That's who we're trying to help. That's when we make progress. That's when you do things together to make a difference. And I applaud this bill. And we'll continue to work together to make things better. So thank you.
Thank you both, and I want to also thank former Secretary Harvey for all the work that he put into this and the cooperation. And this truly was an open collaborative with open discussion, speaking freely, and all the staff input was critical to this. And Roberta Kaiser, again, Roberta, can't thank you enough for that. We have a good foundation in place. We have the structure in place to move forward. We'll have the regional centers. We'll have violent, nonviolent, segregated. We'll have females segregated, violent, nonviolent. There's a new secretary. There's a new commissioner. I'm hearing rumors that decision may be coming soon as far as a new commissioner for DJJ. And we've done a lot of good work resulting from the working group that we had last session, and everyone who was a part of that. I can't thank you enough for that. But please take the time this week, all of you, to review this, and let me know if you have questions or suggestions on how to make it better. Anyone have any questions now that, and again, I know it's a lot to take in, but it really is a good structure to address this issue. And we're not going to have these kids, once we get this facility built, locked up in a cell, naked, sleeping in feces, no treatment, minimal treatment. That's just not going to happen anymore with this. And you all do need to understand that although there's not an appropriation with this, we're looking at approximately $45 million for each one of the female detention centers. And there's a total of about $165 million for all the retrofits and for building the new facilities, including $22 million for the DJJ mental health facility. So this comes with the price tag. And, as the budget moves forward, we have some decisions to make on this. We have directed the cabinet to do certain things, and now it's time to fund those things. And, as far as the mental health, that was one of the most pressing issues. This is a solution to that problem, and it's not cheap. And so we will have to make those decisions as we learn about the budget, as we take those votes. But I want you to know that is the appropriation request that the cabinets have submitted, plus the addition of the $22 million. And then there's also some maintenance pool funds that go into that. Senator Westerfield, I cannot believe you don't have any questions. Please.
Chairman, you've done great work here. and you and I have talked about this, so I knew what the proposal looked like. You've heard me say a lot of times my concern is that we only ever respond with a penalty. We only ever respond with a punishment or some sort of consequence, and that's important, and we should. But to not respond to the behavioral health crises that these kids and their families are clearly facing in every single circumstance, in one variety or another, is legislative malpractice. And we can't ignore that, and your bill does not ignore that. I commend you for it. You've worked hard, and I can vouch for what Secretary Friedlander said. You've held their feet to the fire, because I've watched them come in to have the meetings that have lasted a long time. And I'm glad you've dug in and forced them to do what, again, Secretary Friedlander, as he said, to do what their agencies are both designed to do. I like the bill.
Thank you, Senators. That's all I have. Roberta, can you think of anything that we haven't covered? Okay. Again, plowing new ground, and I think it's pretty neat that the two cabinets are partnering on this to solve a problem to support these youth in our Commonwealth. And my hope is we're going to go from being one of the worst states in this area to the best. And I think we have the potential to do that through this process, through building the facility, and we'll be taking care of these kids. And the travesties that have occurred in the past simply won't happen again. And with with all the two cabinets and the hospitals working together, I think we can come up with some good answers and good treatment and do what's best for the kids. So. And I do want to mention again the Hospital Association, Nancy, and all the folks represented in the meetings from the providers. Very good information, very good input, and I think a good product. And Nancy, I don't know why she's not here today, but she was instrumental in pulling all this together and everyone working together.
I think there's some sort of big KHA function today.
Was there?
Yeah.
Okay, since Senator Webb is here now, we're going to do it all again. Yeah. Senator Webb, we have two bills, House Bill 333 and House Bill 561. Would you like to cast a vote on those two bills? An aye and an aye. Okay. All right. If there are no further comments or questions, I'll entertain a motion to adjourn. We stand adjourned.